The H1B guy here. And today, the H1B guy ponders, will the H1B travel ban be upheld or a preliminary injunction ruled? But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B guy channel here on YouTube. It helps me to produce more content like this for you. I also wanted to remind everyone that the H1B guy offers consulting services for both employer and employees alike, whether that's individual case review, audit and compliance management, program and process improvement. The H1B guy is here to help you. Please reach out to me if I can assist you in any way. On Friday, September 11th, the U.S. District Court for the Northern District of California heard the case of the plaintiffs, including the National Association of Manufacturers, U.S. Chamber of Commerce, National Retail Federation, TechNet and Intrax, against President Trump's administration, challenging the Presidential Proclamation that suspended entry to foreign nationals that are currently outside of the country on H1B, L1, and other visas. We previously covered this lawsuit back on the H1B Guy News for July 24th, 2020, and another Stuart Anderson piece titled H1B Visa Lawsuit, Trump Takes Sledgehammer to Immigration Law. This time, Stuart Anderson from Forbes covered the hearing in an article titled Federal Judge Hears Arguments Against Trump's H1B Visa Ban, in an article that posted today, September 14th, 2020. Quote, the critical question before Judge Jeffrey S. White: does the president possess essentially unlimited power to override immigration laws passed by Congress and block any visa holder from entering the United States? The article quotes a brief from the motion that said, quote, the proclamation exceeds the president's power under Section 212F because it directly conflicts with congressional judgments embedded in the INA. Congress specified that certain guest worker programs are in the national interest, but for more than 6 months, the proclamation nullifies those statutes. Greg Siskin of Siskin Susser, in an interview, said, quote, the government argues that Section 212F gives the president extremely broad power to ban people. But if you buy that argument and that Congress's immigration framework can be ignored, then this is an unconstitutional delegation of the Constitution's requirement that Congress regulate immigration. As we've covered on this channel during the H1B Guy Reads Between the Lines, Presidential Executive Order targeting H1B and offshoring, and also for the H1B Guy News from July 24th, 2020, where we said that the president, with several strokes of a pen, can, quote, whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such a period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Buried way down at the bottom of Section 212 N1 of the Immigration and Nationality Act gives the president this authority. The lawsuit is challenging the president's authority under 212F to impose the ban on guest workers, as it is in the job of Congress to regulate immigration, not the president's. Quote, Joshua Press, an attorney for the Department of Justice, argued, a president does not need for a proclamation to be supported by a record at all. He said Section 212F is clear and concise, and that all a president actually needs to make is a finding. Remember when we said that in the H1B Guy Reads Between the Lines, the president executive order targeting H1B and offshoring, that the president can, quote, whenever the president finds entry detrimental to the interests of the United States, restrict travel based on 212F. The Department of Justice is merely using that language as validation of the current travel ban. Quote, Paul Hughes of McDermott, Will, and Emery, counsel for the plaintiffs, in a response to a question from Judge White, Hughes attacked the administration's argument about supply and demand and that all workers are fungible. Hughes noted that the administration itself does not believe all workers are fungible, pointing to the exceptions included in the proclamation for workers in food supply or in medical fields responding to COVID-19. The straightforward answer is employment is not fungible, said Hughes. Because somebody is unemployed in one job does not mean that individual has the skill set to satisfy other jobs. Fungible, per the definition from Oxford Languages, quote, of goods contracted for without an individual specimen being specified, able to replace or be replaced by another identical item, mutually interchangeable. Here, the plaintiff side is making the argument that not all jobs are created equal, meaning that individuals that perform them are not equal either and cannot be easily replaced. Sounds like an argument based on specialty knowledge. It's no secret that the current administration does not value the temporary foreign worker in the technology space. The question becomes, are jobs fungible? Some will say yes, others will say no. I think I'm in the no category on that one. Getting back to the article, quote, Judge White asked what principle should be used to evaluate the proclamation. I think the principle is that there ultimately has to be a reasonable connection between the stated problem and the action that is ultimately taken, said Hughes. He argued that the proclamation does not make a connection between H1B and L1 categories and COVID-19 related unemployment. The plaintiffs here are arguing that the Presidential Proclamation limiting temporary foreign workers, primarily H1B and L1 visa holders, due to unemployment caused by the pandemic, is not corollary to the low unemployment rates in the computer occupations data we see supported later in the article. Quote, Paul Hughes noted that the L1 category requires someone to have at least a year's experience with the company, which is obviously not fungible, said Greg Siskin. The government response here was particularly weak. This is what makes the L1 unique. It requires a minimum of 12 months working for the company before a petition for an intercompany transfer to a U.S. location can even be initiated. Back to the article. Quote, I think most of these affected companies would involve not the type of services and sectors and jobs that the president was most concerned about, said Press. But people can actually sort of do those jobs remotely, is really what I'm getting at here. And I don't see the emergency, much less irreparable injury to any of the companies as to why those employees cannot be brought in. I don't think there's been anything on the record at all from them when it comes to the L1s. So here's the Department of Justice arguing that L1 jobs can be done remotely. Do you agree with that argument? In most cases, that answer would be yes. But as we've seen the rapid escalation to the remote workforce in the last 6 months, it still isn't 100% accurate for all L1 employees. Back to the article, quote, citing a NFAP analysis data that showed the unemployment rate for individuals in computer occupations remained stable in the United States between January and May of 2020. We've covered an NFAP analysis of H1B denials a few weeks ago. The NFAP is non-political, non-partisan, and here they use the Bureau of Labor Statistics in an analysis of computer occupations, which include computer and information research scientists, computer and information systems managers, computer hardware engineer, computer network architect, computer programmer, computer specialist, computer systems analyst, database administrator and architect, information security analyst, electrical and electronics engineer, network and computer systems administrator, software developer, software quality assurance analyst and tester, web and digital interface designer, and web developer. A lot of the specialty occupations which we see H1B visa holders employed under. It's not a question, back to the article, sorry, quote, it's not a question of competing methodologies since President Trump's administration did not cite the unemployment rate for computer and mathematical occupations in its proclamation. If you recall, back on June 22nd, 2020, President Trump issued a continuance of the Presidential Proclamation on April 22nd, 2020, that was deemed, quote, suspension of entry of immigrants who present a risk to the United States labor market during the economic recovery following the 2019 novel coronavirus outbreak, continuing the suspension and limitation on entry of H1B, H2B, J, L, and permanent residents, green card holders, out of the U.S. until December 31st, 2020. However, per the plaintiff's argument, there is no reference to computer and mathematical occupations, and they are not wrong in that. There literally is no reference to it in the proclamations. Per the NFAP analysis, unemployment for computer occupations was at 2.5% in May of 2020. So why does the ban remain? Back to the article. Quote, near the end of the hearing, Hughes argued a preliminary injunction was necessary to prevent irreparable harm to companies. Without a preliminary injunction or a favorable decision for the plaintiffs, the ban on entry could remain in place for years and could even be expanded. That's a pretty scary statement. The possibility of a travel ban on H1B and L1 visa holders indefinitely and the impact that will have on employers and our economy is simply unfathomable to me. And finishing up the article, quote, in 2020, administration officials became further emboldened and used Section 212F to block the entry of almost all immigrants and employment-based temporary visa holders to the United States. In few immigration cases have the stakes been this high. This case has huge ramifications. If there is no preliminary injunction issued, then the courts are siding with the president and the executive branch, upholding 212F and the president's right to enact it. Quoting Joshua Press, all that the president actually needs to make is a finding. There's a reason we have three branches of government, checks and balances primarily being that reason. Does 212F give the executive branch an imbalance of power as it relates to restricting temporary foreign workers? The Department of Justice case came off as weak and borderline arrogant. Will be very interesting to see how this case is ruled over the next couple days. One thing is for sure, and that's this. This will not be the last H1B lawsuit we'll see as long as the travel ban remains intact. For the full post, please check out the H1bguy.com. And if you haven't already, I'd like to ask you to please like this video, please subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications. If you've made it this far, I just want to thank you for your support and taking the time to watch my content. Really appreciate it. The H1B Guy, your global source for all things H1B.